Good evening, denizens of Dominion. Welcome on in to the evening portion, part 2 of tonight's From Day 1. And I have a good friend of the channel, Law Talk with Mike, along with us. Got us some interesting court situations and moments for us this evening. So we start with some wild court moments. This is from Court 3B of Judge Middleton. And let's begin.
All right. Mr. Bush is back. That was a handy device to be able to use the conference room. While you were out of the room, Autumn gave us a little bit of update. Autumn, would you repeat that for the benefit of Ms. Dell and Mr. Bush?
I apologize. I was updated by Day Reporting Center staff on Monday, August 30th, that Ms. Becker had went in and tested on August 19th as she had been directed by the court. She was positive on that date for methamphetamine. The cutoff for that confirmation is 50,000 nanograms. Her methamphetamine level was greater than 50,000 nanograms. She tested again positive on August 24th, again for the same amount of level, greater than 50,000 nanograms. She was then no-show for testing with them on August 26th and August 27th.
Cammy?
Okay, so we have a lady who's basically on drugs, failed 2 consecutive drug tests, then, when being tested twice more, said screw this and decided not even to show up. Oh, how could this get worse?
We also learned you were in the Branch County Jail yesterday or the day
I had to open my mouth, didn't I? I guess that's how it could get worse. Go ahead, Judge.
before. Why were you in Branch County Jail?
I got picked up on a warrant from June.
For what?
Misdemeanor refraud.
All right. Is that case still pending over there?
Yeah, I'm out on bond.
All right. Mr. Bush is back with us, and he's on camera.
Okay, so here we go. You can see it's sort of a sad situation. We've got another meth addict here, and she's in violation of her probation terms. And it's just an interesting hearing for a lot of reasons.
Mr. Bush, you've had an opportunity to speak privately with Ms. Becker. What does she wish to do here?
She wants a hearing, Your Honor.
All right. Ms. Becker, would you please raise your right hand? Tammy, can you hear me? She's frozen. Autumn, would you raise your right hand? Tammy, would you raise your right hand? You swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief.
I do.
All right. Ms. Kiefer, hearsay is admissible in a probation violation hearing, but some of this is your directly knowledge and some of you were informed by the Day Reporting Center. Is it true that Ms. Becker was placed on probation on August 20th?
Well, that's interesting. He says that hearsay is allowed in a probation violation hearing, which makes a lot of sense. Hearsay is one of the biggest problems because then you have to bring all the witnesses in live. But they're trying to expedite this service. And the witness is a probation officer. The judge is going to know the officer and have a good sense of what it is. But it's interesting that that's specifically set out probably in the code somewhere.
28 on a
Highly likely, Mike.
methamphetamine.
He was placed on probation on January 20th.
January 20th. I saw the of 2020.
That's correct.
And you filed a probation violation petition alleging violations. What are those alleged violations?
The violations were that Ms. Becker tested positive for methamphetamine on January 31st, February 3rd, February 7th, February 10th, February 11th, the 14th, the 17th, and the 18th of all of 2020.
So in other words, she failed every fucking test. Jesus Christ.
He was also then a no-show for testing on February 19th and February 24th.
And then
So she knew she was going to fail everyone, so 2 of them, she just said, screw it, I ain't going to show.
she last reported on February the 4th.
That is correct.
And then she was off our radar until she got picked up on the bench warrants
Sorry,
September 7th. Is that correct?
Actually, I have on the status report she was arrested on September 8th of 2020. She was seen by Your Honor on September 10th.
All right. Gave her 3 days in jail for failing to appear and set the PV hearing for today. You also provided an update to your report Ms. Davis, do you have any additional questions for Ms. Kiefer?
I do. Ms. Kiefer, is it true that there was actually a probation violation hearing scheduled in October of 2020 after the initial arrest in September of 2020?
Correct.
And did Ms. Becker appear for that hearing as scheduled?
In my notes here in our register of actions, October 12th of 2020, the bench warrant was issued by Judge Middleton for failing to test at the DRC as directed.
It's almost as if Deborah knew the answer to that question before she asked it.
October 15th,
That would be a good prosecuting attorney, eh, Mike?
Judge Middleton ordered her to turn herself into the jail by 3 o'clock, so she was seen. However, Ms. Becker never did turn herself in as ordered by the judge at that time.
Autumn, is it also true that the new Branch County charge could be a basis for the violation of a probation?
It could, if Ms. Becker stated it was from an incident in June. She was on probation at that time, and that would be a direct violation of Article 1.
Mr. Bush?
Okay, so we're going to the defense attorney here, and that gets fairly interesting, but I wanted to leave a baseline. I edited a lot out. This was a lot longer hearing, but you get the idea. She's in violation. She has a lot of positive drug tests. She fails to report. She fails to do everything she's supposed to do in her probation, and that's why we're here right now. And she also gets picked up on other charges.
Do you have any questions for Ms. Kiefer?
Yes. So the record's correct, Ms. Kiefer. She hasn't been discharged, so Tammy Becker is still on probation.
That is correct.
And you went through a litany of February of 2020 tests that were positive. Were those all done at the Day Reporting Center?
Yes, they were.
Can you describe the type of tests those were?
They should have been urine tests. If they were not, she was ordered to comply with CPS as well on her judgment. We were letting her test for them because they were paying for her test. That way she wasn't having to pay out of pocket.
And Mr. Scott or his office was sharing those results with the district court probation office then?
Correct. Bob Scott was. I don't want to stop you, John, but Amy, are you there? Still there? It looks like you're frozen.
Yeah, now I can hear you. Hold
Oh, watch this. I know this is a serious situation, but this part is humorous. Just watch Deborah Davis. As usual, her facial expression reflects exactly what I think of the situation.
on. I gotta get people to turn off their Wi-Fi. Howard, turn off your Wi-Fi, please. Howard!
Yes, that was prosecutor for, oh no, you didn't.
Sorry, I just didn't want her to miss anything.
Tammy, can you hear us?
Yeah, now I can.
All right, very good.
Ms. Kiefer, during these proceedings, did Tammy ever question any of the test results or give you any explanation of why she felt she was not using methamphetamine?
She usually always did. She always had an excuse. She felt that CPS at that time was trying to make her look like a bad mother. She always had an excuse for every positive test.
Did she ever admit to any positive test?
I would have to go through all my notes. It's been so long since I dealt with Miss Becker in this case.
Well, in your report, you said Cammie texted Bob Scott, wanted to notify that she was sorry she screwed up.
Did Cammie?
That's Judge Middleton telling the defense attorney, don't bother with this. She's made admissions, right out there. I get you're trying to help, but let's move it along in the nicest way possible.
Do any other services? Did you ever get going in treatment or counseling?
I don't believe so. We never really got off the dime on this probation, even though Cammie was very adamant that she was going to be able to make it through. Looks like she was authorized to attend a substance abuse group therapy.
Thank you. I have no further questions.
Mr. Bush, does Ms. Becker wish to testify?
Yes, she does, Your Honor.
Oh, no.
Cammie, you're under oath. Your lawyer has some questions for you. All right, John,
This can't be good.
Ask her what she wants us to know, or do you want to do a dialogue with her? All right, go ahead, John.
Cammie, you understand now that you are still on probation, and you were able to hear most, hopefully, all of Ms. Kiefer's testimony.
For the most part.
And so we don't beat around the bush. Were you using methamphetamine in February of 2020?
No, sir.
Do you have an explanation of why you had repeated positive methamphetamine tests?
No, actually, because all the positive tests from February 2020 and January of 2020, the only positive tests I had were the mouth swabs per CPS. All my urine tests at that time through the DRC, which you can go back and get the records from DRC, were all negative for 40 days. All negative.
I feel for this defense attorney right here. Clearly, he conferred with his client prior to this, and he's going to give her day in court. This defense is awful because she makes a bunch of contrary admissions, as you'll see as we go, and it's, but he's saying, all right, fine. You want to say that some of the tests are false positives? I'll let you say it, but he knows it's going nowhere, and he's just, it's interesting with practicing law. You don't get to choose your facts, and if you have a client that's as guilty as this one is, and the evidence is as strong as it is, there's not a lot you can do. So he's doing the best he can with the bad circumstances.
So, auto using my tests per CPS, the mouth swabs that are only 46% accurate, okay, versus my urine tests that were all negative.
Oh, wait a second. I got to pull that back. You get once again, Deborah Davis telegraphs my thoughts exactly.
Mouth swabs that are only 46%
right here.
accurate, okay, versus my urine tests.
Oh, Jesus, I didn't catch it the first time, Mike. Damn it.
To your knowledge, did you ever have a positive?
She gave her an eye roll like, really?
Absolutely. At that
Which one?
time, no. But have I in the past and have I recently? Yes. Yes, I have.
Did you complete any of the services that were recommended by Community Mental Health?
I haven't completed, but I am still in community mental health. I am still going to counseling. And actually, I believe August 12th of this year, I was in CMH office. Actually, it was the day that we had that really, really bad storm. I was in CMH office trying to get into rehab. And that's why I'm continuing with my community mental health. Because to me, that's top priority. That and my substance abuse. I am
Community mental health, she said.
I can't help that. But I'm trying. I said every week I've been going to see Bobby Joe Newland with my wife because my wife is on parole. And she has seen me every week for the last 9 months.
That was great because we had a warrant out for you for all that time, so it's a clear case of the right hand not knowing what the left hand was doing.
Yes, Judge Middleton.
Bush.
In all fairness, I had to edit a lot of this, and it makes Judge Middleton look harsh there, and he really isn't. This woman's a drug addict. She's very manipulative. It's annoying after a while. I feel for her. I have empathy for her, but she is not honest. And she's not playing the game. You'll see even more as it goes on. But I felt like I had to put that in there. It looks a little out of left field, but I cut a lot out of this.
There's an allegation that you were positive just a few weeks ago on August 19th and August 24th. And I believe those were urine tests.
Yes,
Do
sir.
you believe were those accurate?
Yes, sir.
So you had a relapse then?
Yes.
Have you used since that day?
Not really. I mean, once I think, but
Not really?
I mean, right there is what I'm talking about. Have you used since that day? Not really. Well, of course, the answer is yes. It clear as a bell, and she sort of even gets to that. But she starts with not really, and you see so much that after a while you start losing your mind, and you start looking at her like Deborah Davis and responding like Judge Middleton. You can't blame them.
I went to jail 2 days ago, and just like, what do you want me to say? I'm a drug addict, and I've been under a lot of stress. I've been dealing with a lot here the last few weeks, and I relapsed.
What do you want the court to do with your probation today?
I don't know. I don't know. What can I do? Do I want to revoke? No. I would like the chance to continue on because, like I said, I've been clean. I was clean for 6 months straight, but then I relapsed. But I've been trying.
Any further? I guess, are you homeless today, or do you? I mean, obviously you're not in jail. Do you have a place to live and sleep?
I'm currently sitting at my mom.
And your mom is Darla Beebe?
Yes, sir. She's sitting right next to me.
Okay. Cammie, is there anything else you think Judge Middleton should know or understand about your circumstances? This is your chance while you're under oath to testify.
Like I said, I've been clean up until the beginning of, or in the middle of August, right before actually I got arrested. And You know, yes, I will admit I relapsed recently. You know, I tried to get into treatment before I was arrested.
All right, thank you.
Thank you, Judge.
Deborah, I don't know if I need any more. Anything you wish to ask?
No, we have DRC if necessary to testify about the testing, but I don't believe under the circumstances of the admissions that she's made that that's necessary.
Cammy,
Other,
I
she
can
fucked
tell
up.
you were on meth when I talked to you the last time, which is why I told you to go test here in August. You're very defiant, very unrepentant. The fact that you're trying is a start, but you went AWOL for more than a year. And the fact that you're going in to see Bobby Joe every week, knowing you have a warrant out for your arrest. Bobby Joe didn't know you had a warrant out for your arrest, but
Yeah, I agree with you, Mike.
You were poking me in the eye with a stick at the time of the hearing, and then you tested positive for meth, and then you got picked up on an old warrant, which is still unresolved. So I find that you are in violation of your probation by failing to report, and on at least 2 occasions that you admit, probably many other occasions, you were positive for methamphetamine. Originally, you were supposed to turn yourself into the jail, and you gave me the finger. Last time I gave the finger, it showed up somewhere, so I won't do that. But you, me, and my horse. What's your recommendation?
The recommendation is for her to serve the deferred time. It was 60 days in jail. She had served some. I'm not sure if you are willing to give her the day that she spent the other day. 55 days in jail.
Mr. Bush, what's your thought here?
Suggest to the court that any progress is a step in the right direction.
That's attorney speak for I've got nothing.
Yeah, I got nothing, please, Your Honor, be kind.
With the court, there's also, we have to have some consideration to rehabilitation. She's saying the right things today. The court and counsel are all aware of how seriously addictive methamphetamine is. There probably needs to be some form of punishment. I'm not sure it needs to be the full 55 days, either to get her cleaned out, continue her probation, or to get her system clean, to discharge her and allow her to make her own informed decisions after that regarding any treatment.
Cammy, I'll give you the last word. Anything you want to tell me?
I'd like to speak as well, too, but...
Well, let's hear from Ms. Davis, and then we'll hear from Cammy. Ms. Davis, what's your thought here?
Your Honor, the court considered all of the factors, considered the history of Ms. Becker at the time of the sentencing, and with all of that, 55 days were reserved. Those 55 days hanging over her head to get her to comply with treatment and counseling and getting a job, getting a stable place to live. And she has done nothing to improve her situation. What I'm hearing today is a lot of minimizing of what her problem is. She has another apparently theft charge. When I look at her history, retail fraud, lots of theft, and then drugs. And she isn't ready to do this on her own. I think that a stay in jail is appropriate. So the reserve days that were contemplated at the time she was originally sentenced, as well as 3 additional days for the 2 each time that the court looked her in the eyes and said, go test or go turn yourself into the jail, and she chose not to. I think there was 2 times for that, so these 6 additional days in jail for that contempt. What I'm hearing today again is she doesn't have a job. She doesn't have a place to live. Her spouse is incarcerated and has a parole hold. The safest place for her to detox is the St. Joseph County Jail, and she can get some treatment started. She can get in touch with CMH through there, and it's not that I'm trying anymore. It's either you do it or you don't, but you're going to be in jail while you figure it out, and then hopefully if she avails herself to the services that we do have, she'll get out after her jail stay and be able to be successful. But this probation went nowhere. It shouldn't be continued.
All right, thank you. Just 1 minute, Cammy. All right. Cammy, what would you like me to know?
Like I said, I tried to go into rehab, I believe August 12th or August 14th. You know, I'm a drug addict.
Yes? Well, you don't have to apologize. I mean, you are When I tell people to stop using meth, it's like saying, hey, why don't you stop breathing? But it was everything else that you did. People often want to go into rehab when they're about to go to jail. You need some rehab, but you also were terribly uncooperative in this probation. And you were off the grid for more than a year. A year and a half. You disappeared in February of 20. We didn't catch up with you until August of 21. I'm going to continue your probation as you request. You also told me you were going to turn yourself into jail, and you did not. I'm going to order 61 days jail credit 1 to start tonight, 7 p.m. today, 9/1 of 21. You're still on probation. If you don't turn yourself in, I can execute the rest of the 365-day jail sentence. Your detox needs to start with some...
What's that? What do you mean?
If you don't show up at jail today at 7 o'clock as I'm directed, it will be a further violation of your probation. The maximum punishment is 365 days. So I'm ordering 60. But if you don't show up, you got a bunch of jail hanging over your head. You already pimped me once when you said you were going to show up a long time ago.
Oh yeah, he just said that.
Yeah, he did.
Here in person today. So you're going to turn yourself in at the jail at 7 o'clock tonight. We're going to start a 60-day jail sentence with good time, which will be 50 days. Then, when you get in jail, I'm going to explore getting you in an inpatient program with Lisa at the jail. So it isn't like you turn it on like an on and off switch. It's a very difficult process. But you were very defiant, very uncooperative, and it was always somebody else's fault. Well, now the fault's right on top of your head. I'm not going to do any slam dunk. I'm ordering what I originally deferred, which you've earned. 60 days jail, credit 1, probation is continued. You're to turn yourself in at the jail tonight by 7 p.m. If not, there'll be a warrant for your arrest.
Okay, so how much longer are we going to keep her on probation after tomorrow morning when we check?
Wait a minute. So my probation's already ended. So he's keeping me on probation so that he can violate me again if I don't show up to jail. How is that fair?
Who says it's fair? This is something you earn. If you show up tonight at jail, then you don't have to worry about it. If you don't show up, you're subject to further probation violation. You've not been discharged from probation. The court has jurisdiction to keep you on probation for 24 months. And you don't get under that hurdle by absconding and say, well, more than 24 months is up, you can't violate my probation. You've been on abscond status for a year and a half. Show up tonight at 7 o'clock. We'll start the jail sentence. You'll get good time. We'll work on getting you into an inpatient program while you're in there. I suspect you're going to test positive right now. You need to break the cycle, and we're going to do that by some forced incarceration. All right, Kenny. We'll look at this in the morning. I expect you to be there.
Thank you, Judge.
Thank you, Your Honor.
Well, there you have it. I thought that was fascinating. I couldn't believe at the end that she was trying to argue with the judge. The judge was, Judge Middleton was sort of talking tough, but he was really actually very nice. Even her defense attorney had sort of given up, and rightfully so. He can't push there. She's done everything wrong. She violated probation. She's been rude to the judge. Everything you can do. So he can't sit there and say, "Oh no, she doesn't need to go." She needs to go. She needs to be put someplace and get into treatment and certainly be taken off the streets. But I just found it fascinating. She thought she could argue about it, and I'm sure the defense attorney wanted to do something, but he's in another room. It looks like he's in the actual courthouse with Judge Middleton, but his client's in another place. So you can't really stop it. It's another strange aspect of the Zoom proceedings. Here at Law Talk.
Thank you, Mike, but stay with us because I have another one for you. As they say, let's begin as we start round 3.
Bargain that Mr. Schultz with the city was referring to. You just want to have a seat and take a look at that. Okay, and in the meantime, we'll call Christina Dawson. Miss Dawson, can you please unmute yourself? There. Thank you. Good morning, and for the record, can you again tell me your name?
Christina Dawson.
Thank you. And Ms. Dawson, you're here for your mandatory pretrial hearing. I have your attorney, Mr. Pasco, present as well. Go ahead, Mr. Pasco.
Thank you, Your Honor. Ms. Dawson has informed me that she would like to make 3 statements related to this case procedurally. I offered to make them. She preferred to make them. I'm okay with her making them as long as she doesn't talk about the night of the incident. And then when she's finished making those statements, it's my anticipation we just ask to set the case for trial.
Sure.
Okay, that sounds like the defense attorney going, I told her 8 ways from Sunday, 8 ways from Sunday not to do this, but she can't be bothered to get out of her own frickin' way, so here we go. But Mike, you wanted to say?
Translation. I think this is a horrible idea, but she paid me, and I tried to at least explain to her what she can and can't say. Let's see what happens.
Okay. All right. Go ahead, Ms. Dawson. I just want to caution you, we are being recorded in court. So like your attorney said, please don't say anything about the facts of the case. Even if it's something you think could help you, it could be used against you in the future. With that said, go ahead.
Yeah, and again, this is something, whether, it's me that says it or him, I'm perfectly fine with, but speaking with another attorney and also somebody who is a good friend.
Okay, I'm going to stop her right there. That can't be good. If she's going to immediately go into something like that, this is something where I'd be like, shut up! Shut up! Shut up! Shut up! But I have a feeling that she's not going to do that.
A friend of mine that is a retired police officer, some information that I've had to do most of all my research myself, it seems. And one of the things in general was the report, the toxicology report. One piece that, again, it doesn't.
Okay, what part of do not talk about facts of the case you do not understand? That sounds like exactly what the hell you're doing.
Have to be selling trial, but I can tell you now, is that when the so-called evidence in these blood tubes were received by the Washington State Patrol Toxicology Lab, they made a note here. It says, observe the following, sample unlabeled. So that's concerning. A friend of mine who is a retired officer had said, that right there, the case should have been thrown out. The second piece is, these labs were drawn, and I know the lady had at the hospital. I worked at Peace Health for 15 years. I'm a nurse. She handed me the tubes, had me confirm that it was my name, date,
I mean, look at this. Look at the expression on her attorney's face. He's absolutely in pain. She's doing exactly what the judge admonished her not to do, which is going straight to the facts of the case. This is a horrible idea on every front.
Extremely horrible.
But we're hoping the attorney's just hoping it'll be short, and so is the judge. But she goes on.
Hi, this is Frankie with the Sovereign Citizen Patrol, and I'd like to remind you to please.
Oh, Frankie's awesome. Now be kind.
The information was correct on those tubes, and then handed them back, and I signed something, and then she gave them to the police officer. So again, I know my tubes had my sticker on them. They were then placed in a locker, supposedly per the officer, for 11 days. And then,
Dawson, I'm just gonna pause you for a moment there.
Sure.
It sounds like
It sounds like the judge is going to try to derail her stupidity, but let's listen to the judge.
Bringing up some evidentiary concerns. I don't know if you're ultimately requesting for certain evidence to be excluded or suppressed, or if you're challenging whether the case should be dismissed. But if you're doing any of these things, you still have an attorney representing you, and your attorney would actually need to file proper motions before the court. There's no action that this court could take today on any kind of motion to suppress evidence or exclude evidence or any kind of motion to dismiss. So there needs to be something formally in writing submitted to the court, and then we need to set that for a separate hearing.
Well,
that is just spot on from the judge. Of course, she knows what she's doing. She was very patient with it, and then just saying, look, you're basically making an oral motion to suppress, and that's not how we do things around here. This woman does not understand what that is, as you'll see. She carries on. But this is just not a good idea at all. There might be some good reasons to file a motion to suppress, and the basis for it might be okay, but now is not when you bring it up. Nothing good can happen, and a lot bad can happen.
Mentioned that he spoke to the prosecuting attorney, And they were gonna.
Christina?
Just set this for trial, please, Your Honor.
Oh my God,
Okay.
All right.
Mike,
was
Mike.
That is the prosecutor barges in with, can we just set this for trial?
Yes.
Actually being nice. What he's saying is, I can see this defendant destroying herself. Can we just cut this off and set it for trial? He's just trying to help move it along. Everybody here understands this except the defendant.
That if you knew this evidence, that you could possibly get this thrown out just on the three things that I had.
I suggest you speak with your attorney.
Yeah, it's not anything that we could address today. The limited thing you're here for today is called a mandatory pretrial hearing. And so at this hearing, we'd either be setting your case for a change of plea or we'd be setting it for trial. Again, if you're trying to suppress or exclude evidence or trying to have the case dismissed, that's a formal written motion that would need to be submitted to the court, and we'd set a hearing for that. Because
I'm not trying to suppress anything.
If you have an attorney representing you, those motions would be filed through your attorney.
Right there, she says, I'm not trying to suppress anything. It's exactly what you're trying to do, and that's the right thing to do. But you don't even realize it. If your attorney's aware of these things, if those arguments have merit, he will file a motion to suppress. If you're making an argument that they can't have a chain of custody on their main evidence. If you get that evidence suppressed, the state can't meet their burden. Then you move to dismiss. That is the process of what is going on. And the judge even says it to her. And then, of course, she argues with the judge. She knows better than the judge as to what she's doing. Oh, Lord.
But there
can he mention these three things?
The court do today. Pardon me?
Can he mention these three things? Because I asked him yesterday if he was.
So if your attorney's representing you, it's going to be his decision what motions are brought to the court's attention. But I can't address any of these issues today at your mandatory pretrial hearing. So I'd encourage you to get in touch with Mr. Pasco about how to approach these procedurally.
Okay.
The answer is yes, he can mention these things, and if they have merit, he will mention these things. But today is not the time or place for it.
Okay.
Correct.
And then we're going to go ahead with setting the case for trial today. Let's see, because of the excluded time period for COVID, today is our speedy trial commencement date. That means we'd need to set for trial by June 22nd. Mr. Pasco, we have trial dates at the end of May or beginning of June. So either May 26th, get my correct calendar. Either May 26th or 27th. The 26th is a Thursday, or June 2nd or 3rd. So our Friday dates are May 27th or June 3rd. Any preference?
Either's fine with myself.
Pardon me?
Either one is fine with me.
Okay. How about Mr. Schultz with the city? Any preference?
What date was it again, Your Honor?
Either the Fridays are either May 27th or June 3rd.
Do we have any 2-day consecutive period of time?
It's always going to be a Thursday and a Friday. So there's also May 26th or June 2nd, but our trial dates are Thursdays and Fridays now.
Judge, can I say something?
No.
Not right now, just a moment.
Okay. Sure.
Let's take the second in time then. What was that?
June 2nd?
That'll work.
Okay. Ms. Dawson, are you available
Yes.
for trial on June 2nd?
I am, but like I mentioned, I'm not trying to exclude anything. But
Shut up!
The blood draw was done 3 hours after I was taken, more than 3 hours after I was taken in. I've been told it should have been done 2 hours. But then
Jesus Christ, Mike.
This just shows she didn't understand anything that just happened prior, and she's carrying on with the same stuff. Your case just got set for trial. Okay, if you want to exclude evidence, you need to file a motion. If you want to file a motion to dismiss, you file that. Again, there's not something where you just show up like Perry Mason and drop a couple truth bombs on and the judge dismisses your case. That's not what's happening today.
2 hours.
Oh.
So there's just these extenuating circumstances.
I understand that, but what extenuating circumstances mean for the purpose of a criminal case is you're either trying to get evidence excluded or you're trying to get
included.
Okay.
Shut up.
So you can talk to your attorney about what evidence you're trying to get included, but if you're trying to exclude evidence or trying to dismiss a case, those all need to be written motions filed with the court and set for a separate hearing.
Okay. And do they need to be a full hearing with a trial or just like what we're doing now?
That's what you can talk to your attorney about, but nothing can happen until a written motion is filed and we actually set for a hearing.
Okay.
Okay. All right. So I'm about to give you some future court dates. Give me just a moment.
Heather, please shut up
So
your
Mr.
mouth.
Pasco and Mr. Schultz, if you wanted the readiness to come before this court, we would do it on May 5th. Otherwise, we can do the readiness before a different judicial officer a couple weeks before the trial.
I like the May 5th concept, Your Honor. That ought to give us plenty of time to have all the witness interviews completed, complete any of the necessary hearings from the sounds of it, and then be ready to proceed to trial on the 2nd.
All right. Is that okay with you, Mr. Pasco, May 5th for readiness?
Yeah, that's fine. Thank you, Your Honor.
All right. Thank you. Okay. So, Ms. Dawson, your two future court dates will be a readiness hearing on May 5th at 8:30 a.m. And then trial is being set for June 2nd at 8:30 a.m. Those are both mandatory court dates, May 5th and June 2nd. June 22nd is our speedy trial deadline. Okay, Mr. Pasco, anything else from you?
Nothing at this time. Thank you, Your Honor.
Mr. Schultz?
Nothing, Your Honor.
All right, Ms. Dawson, any questions about the court dates that were set?
No questions.
All right, so please get in touch with your attorney about all of your other questions so that he can address anything with the court that he deems appropriate. That's going to conclude your hearing for today. Thank you.
All right, thank you.
Mike,
Well,
you
there
want to
you have
recap?
it. Effectively, a pro se who's represented. The likely outcome here, I would say statistically, so I don't know the underlying facts in this case, is that this case resolves via plea bargain long before we do anything. If there are problems with the sample or something like that, then your attorney has more leverage on that. If that process is failing, then he's going to file motions to suppress. If all that makes sense, I don't know any of the other facts. Maybe they can prove this DUI up completely by body cam and field sobriety tests and all sorts of other stuff. So I don't know any of that stuff, but it is a horrible idea to spitball defenses that you're not familiar with at the pretrial with the prosecutor there. It's not helpful. Here a lot.
No, it isn't, and I definitely thank you very much, Mikey, for your deal. We haven't had you on in a while, and I appreciate you coming back on with us tonight. All right, Squishy Gardner, a new guy to us. Are you there? Let's go ahead and handle one with you. This boy has some really serious contempt of the judge. We're down in El Paso, Texas, and of course, old Squishy Gardner, if he does chime in, he usually is pretty shy, will be the alternate voice you hear. Let's begin. Well, if I can get the connection up.
We have
There we go.
a Tony Orozco.
Tony Orozco, courthouse calls number 2019-3244 and 6278. Tony Orozco, and ask on the council, please.
Good evening, for the state, Your Honor. State is ready.
And Daniel Aguilar for Tony Orozco, Judge.
Would you waive Mr. Orozco's appearance? I don't think he's present.
All right, just to give you a little heads up on what we're looking at here, this begins with an offer of a rather sweet plea deal, reduction of a felony burglary charge to just a misdemeanor trespass and time served on a state drug possession while in jail. So in other words, a pretty fucking nice cakewalk of a deal for the defendant. But of course, you know, we wouldn't be here on this particular case if something didn't horribly go terribly wrong. So let's continue.
I don't see him, Judge.
Yeah, I didn't let him in. Becky didn't let him in.
May I move the court for a waiver of presence?
Sure, of course. Jesus Armando Cepeda is just sitting there in his car. He has a view of the car, Mr.
Oh, yeah.
That's the last case that was up in front of the judge, is the reference she's making here, and they'll get rid of him pretty quickly.
He's just sitting there like showing off his car or what? There he goes. Okay, thank God he heard me. Okay, he's gone. So you waive his presence. This is a settlement conference. What are we offering at this time, Mr. Nunez?
Your Honor, I'm trying to package the deal where the burglary of habitation gets dropped down to a criminal trespass, and I'm thinking of 1244A in the state jail felony possession. I'll give them time served.
Wow, that's pretty good, Mr. Avila. What are you thinking about?
1244A on the state jail amount?
Correct.
Right.
Then we also have a criminal mischief, and I will dismiss that criminal mischief, which stems out of the same incident as the burglary of habitation.
So the burg
Becomes a reduction to a criminal trespass, right?
Correct. Your Correct.
It's a sweetheart deal. Take it.
Mischief is dismissed. That sounds pretty sweet, Mr. Arlad. What do you think?
Yeah. I think we're about there, Judge, yes.
You want another settlement conference in 30?
About there, what? You want him to give you a box of chocolate too?
3 days, but if you agree to it, just call Becky and just make it a plea.
Would you mind?
No, of course. Of course, the settlement conference in 30 more days. Very well. Thank you. You may be excused on that one.
Okay. Okay, so that is good and happy. Awesome. Squishy, why are we here then? Oh. Proceed.
But thank you, ma'am. The next, did you have another one, Mr. Arla?
I think that's it, Judge. I appreciate it.
But Judge, Mr. Avelar, Tony Orozco, I just admitted Tony Orozco. He's on there, but it says connecting to audio.
Okay. Well,
Oh God, really? Everything went perfectly fine, and now the late boy wants to show up. No wonder why you told me that we should continue. Okay. All right. Let's see what kind of craziness happens now.
call Tony Orozco and tell him he doesn't have to show up. You already took care of that case.
He's already on Zoom, Judge. Please unmute Mr. Orozco. Unmute Mr. Orozco. Oh.
Hello?
Oh, he's there, Judge.
Okay.
Dude, for the love of fuck. Hang up now. Don't say a word. Disconnect. Your attorney did good. The only thing you can do is seriously fuck the fuck up of this stuff. But knowing you, you'll probably opt for that plan C, the fucking things fucking up.
Mr. Orozco, your attorney just took care of your case. You're a little bit late. It's 11 o'clock. The hearing was at 11 o'clock, so it's 11:20. Where were you?
Downloading all this stuff.
I'm sorry?
Dude! It's 2022. A, downloads are not instantaneous. You know this. You download ahead of time. And B, dude, I can already hear it in your voice. You got a fucking cob up your ass with the judge. Drop the attitude.
Downloading the app and doing all this email stuff. Looking for it.
Good idea to download it at 10 o'clock so you would be on time, Mr. Orozco? Wouldn't that be a great idea?
Well, yeah, it could have been an idea, but it wasn't on my agenda right now.
It's what?
Until it ever stopped. It wasn't on my agenda at 10 o'clock.
Okay. Well, it better be your agenda. The next time you're late, you're going to jail, Mr. Orozco. Do you understand? So you better make your agenda. You better make your agenda to show up on time for court.
Well,
You don't.
I'm showing up on time for court, not to Zoom.
Mr. Orozco.
On my end, court.
Mr. Orozco.
I like that. That's his defense attorney. Like, shut the fuck up, sir.
It's yes, sir. Yes, ma'am. No, ma'am.
You're gonna do 3 days. You're doing 3 days in jail, Mr. Orozco. 3 days in jail for your disrespect. I don't care where the heck you are. You're gonna disrespect me. You're gonna respect this system. You're going to jail for 3 days right now. Maybe that'll change your attitude a little bit, Mr. Orozco.
Mad? You don't have an attitude.
Okay, sure.
You so fucking have an attitude. Seriously.
Think about it in jail. Mr. Castaneda, he's going to jail too. He has to turn himself in tomorrow, 8 o'clock in the morning for this disrespect.
Dude, he's fucking shaking his head no on the camera.
Yes, Judge.
8 o'clock, 3 days.
No, ma'am. No, ma'am. No, ma'am.
Now he's saying no, ma'am. Oh, God.
Sorry.
Mr. Orozco, I don't think you understood what.
No.
I like that. The defense attorney again tried to save his client, but it's definitely not working.
He said, I haven't even in my court. I'm sorry. I'm just his wife.
It's 6
Okay,
days.
she's coming on me like this.
And we just doubled the days.
No.
6 days in jail, Mr. Castaneda. You want to keep talking, Mr. Orozco, to make it longer?
Please do.
Mr. Orozco, we got you a fantastic deal. I think.
At that point, he's like, shut the fuck up. Or I'm going to have my friend who has a baseball bat with barbed wire come and start swinging at you. Dear God, I fucking went to the bat for you, got your felony charge reduced to a misdemeanor, got you out with time served on everything else, and you are just here trying to be the world's biggest ass. Knock it off.
There should be a certain level of respect right now, okay?
A lot of respect.
She's not having it right now. I think he's off, Judge.
Wow, he left. He's getting 6 days, Mr. Avelado.
But he's still on, Judge. He's still. I think he's having issues with his internet.
That is good. That is good. That was the voice of the bailiff of this court. Oh, that was good. He still hear Your Honor. He can hear you. That was good. Oh my God, that was good. Okay, back to the judge.
Mr. Orozco, can you hear me now, sir? Okay. Becky, do you know how to remove them?
Now
Yeah.
he's gone.
Becky, okay. Yeah. Okay, Mr. Avelado, it's going to be 6 days in jail. I'm so sorry.
No. I try to diffuse it.
You did. These people just have this major attitude. It's just crazy. Okay, Mr. Avelado, thank you, sir. Be safe out there.
You do the same.
Nice to see you.
Nice to see you, Your Honor. Appreciate it.
Melendez. I'm telling you, people think they can give me and disrespect me and give me crap because we're on Zoom? No way. No way.
You tell him, Your Honor.
And Mr. Castaneda, you let me know tomorrow. What time did I give him tomorrow at noon?
8 o'clock, Judge.
8 o'clock in the morning. If you call me at 8:30, sir. By 8:30, he's not in. We can show a bench warrant.
So in other words, she's getting called at 8:30 because there's no way in hell this guy's showing up. No way in hell. The way he was acting, there is 0% chance that this asshole is showing up. There is no way. This guy had done fucked up. Badly. And same judge. Let's do one more. Please note, Facebook is not your friend. Let's begin.
At this time, court calls cause number 2020-2700, Leonel Vargas, announced on the council, please.
David Nunez for the state, Your Honor. State is ready.
Randy Ray on behalf of the defendant, ready, Your Honor.
This is a bond hearing, Becky?
Yes, Your Honor. I had asked for this to be set in order to implement a PR component.
Okay. Just to put a PR bond component on it, is that all?
Yes, Your Honor, with the court's regular terms and conditions. Also, to let you know, Judge, this defendant's father is also a co-defendant in this case.
Oh, that's this case.
Yes, Your Honor.
I remember. Now, this is in regards to some concerns that the DA's office had. Mr. Nunez, you emailed me. You said you wanted me to put a PR component because there was no PR component in this case, correct?
Yes, Your Honor.
And you also informed me that the father's involved in this case as well, and he's on the run, right?
I don't know if I would describe it like that because I do not know yet, but I just know that he has not been picked up on the warrant, Judge, because the allegations in this case happened in June, or I'm sorry, late May, early June of 2019, and the warrants were not drawn up until, I believe, January, once the DNA evidence came in.
Of 2020.
Of 2020, Your Honor. Yes, Your Honor.
Your Honor, I could tell you about that. The father's a quadriplegic, and they won't let him into the jail. I believe, a quadriplegic. He's bound to a wheelchair, and I don't think they're going to accept him into the jail. So they're going to figure out how they're going to book him without having him go to jail.
Okay. So you just want me to put a PR component on Mr. Leonel Vargas, right, Mister?
Yes, Your Honor. And what I would ask, I think the court would like to see this, if I could have the option to share my screen.
Yes.
And let me know if you want me to stop, Judge.
Stop. I don't see it at all. I'm not seeing anything.
I apologize. Can you see that, Judge?
I can see nothing. I see you. You've not shared your screen. Not David Nunez has started. There it is. David Nunez has started screen sharing. There it is. Now you started right now.
There it is, Judge. So you can see state name matches.
Daily toker. Daily toker means he smokes pot every day?
Yes, Your Honor. I would assume so.
Well, that's nice to know.
What I was showing, going to show judges.
Daily toker. Well, what is that black cat about?
I like that. The Honor wants to know about the cat.
She's my animal, my pet.
But Mr. Nunez?
Your Honor, this is just a regular default picture that I happen to take off of the Facebook actual page. These are also on the initial page itself that I showed. I just have to scroll down, and sometimes it just takes a little bit for that stuff to come up.
Your Honor, if you want to put a component where he does drug testing, some of this stuff might be very recent, some of it could be older. All I know is, do what you feel right, and we'll see if he's a toker. Okay?
That this is after
if he's a toker and a smoker.
He's a midnight toker?
Joker.
That's right, that's the song.
Yes. You guys got my reference.
Hey, people that like to have fun on their Facebook, this is why I don't do Facebook. I'll tell you.
Yeah, nobody should do Facebook like this. They're idiots, Mr. Vargas, for you to do this.
Correct, Your Honor.
Idiot millennial people that think you're tough and a tough toker.
Yeah, Judge, just give him a drug testing so he can prove you right. I mean, not right, that he is a good boy.
No, you got it right. Prove him right.
Like to have fun. They do it on Facebook, and now look at what's going on. Now we're seeing his Facebook. I don't do Facebook for this reason. It's just
about less than a month.
All these millennials do, and they think it's really funny and cute until it comes back to bite them in the butt.
That's right. You see what I mean, Judge? So let's go ahead and do that.
I know, but I have to see the kind of individual, especially with the kind of case he's charged with. This is pretty bad.
You're right, Judge. I'm going to tell him to straighten up his act on this stuff.
And Your Honor, this is about 2 days after the alleged offense occurred.
This was days after the offense?
Approximately 11 days. It happened on the
it's also last year, too, Judge.
June 1st. All these pictures, Your Honor, are after the date of offense. I made sure that the dates are on there, like I showed.
Right.
And like I said, Your Honor, this is the original page that I saved. And as you go down, it's saying...
Yeah, wait, I want to see his profile. Go down. Down. No. I mean, go to the up, then. Up. Okay, go up. Okay, go down now. Okay. I read what I wanted to read. Okay. Anything else you want to show me?
No, Your Honor.
Okay. Well, you look like a gentleman, Mr. Vargas, that continues to make poor choices. It's a bit arrogant, a bit into himself, and up to no good. What can I say, Mr. Vargas? Okay, it's going to be my new and improved PR bond. I'm going to put a 20,000 PR bond, no bars, no drugs, no alcohol, no arrest, no offenses against the state of Texas or any other state. Cannot leave El Paso County unless and until he has my permission. He's going to report, he's going to report 2 times a month to his PR bond officer in person. He's going to report 2 times a month for a UA with 24 hours notice. He's going to have a 9 to 6 a.m. curfew. Absolutely no contact. What's the name of the complaining witness?
That's acceptable to me, Judge.
Right. What else, Mr. Nunez?
Sorry, nothing from me, Your Honor.
Okay, thank you, Mr. Ray, for your patience. Mr. Nunez, anything else?
Sorry, Your Honor, did we implement the 24-hour notice?
I get 24 hours notice. He's reporting 2 times in person, and then 2-time drug testing, 24-hour notice.
And I would also
And what, Mr. Nunez?
just stay away from their residence as well. I understand that shortly after, I believe, the arrest warrants were issued, the house was vandalized. We won't know who. I cannot say who did it, Judge, but it was vandalized. But just out of an abundance of caution, I would like to implement.
So can we just say stay away from Maylin Reyes, her home and her place of employment?
Absolutely, Judge.
And her family.
Absolutely.
Okay. What did you need, Mr. Castañeda?
Were you gonna want me to put a no contact or with the co-defendant?
Well, they live together. I mean, that would be impossible.
Yeah, I think that's impossible. That's Dad, and if Dad's a quadriplegic, yeah. What else? Anything else, Mr. Nunez?
I would ask also that there be no firearms in Mr. Vargas' home. This allegation does, the deadly weapon involved does involve a firearm, and there were also multiple firearms found at the home.
No firearms in the home.
No objection to that, Judge.
Thank you, Mr. Ray. What else, Mr. Nunez?
I think that's about it, Judge.
Very well. Okay. Got it. Okay, Mr. Vargas, you better read. You know this court, Mr. Ray. You know this court. You know he's behaving horribly. You know the choices he's making are horrible. You know in the trouble he's in, he shouldn't be posting, much less posting those kind of pictures.
That's right. That's right, Judge. And I think he knows it too. He's been listening to you.
No, he doesn't know it.
Well, he's just now found out.
And Mr. Vargas, since you're a daily toker, that needs to stop.
Yes, Your Honor, of course.
I'm going to put you in jail. First positive UA, you're going to jail.
Okay.
Simple. Okay. Anything else, Mr. Ray?
No, Your Honor. I have the
Anything
excuse.
else, Mr. Nunez?
Yes, Your Honor, we do have a recommendation in this case. It is going to be 25 TDC, 25 years.
We'll talk about it at another time. I need to go look for my dog. I'll contact you, though, okay?
Thank you. 25 years. Thank you. You may be excused.
Thank you, Your Honor, and thank you, Squishy. With that, we'll bring part 2 to a close. Like, share, and subscribe. Be kind to one another. And it's always a great new world to release to Kraken's next episode in the overnight with our bell as we march through Dominion and the Fungin. Next time, here from Day 1.